Can people hear us? This is Larry, Mike, and Rick.
We can hear you and you're clear and there's no feedback.
Great.
Same with us.
It appears the feedback was with Carolyn's team, I think, because they're on multiple sources in the same close proximity.
Yep, now we're down to one computer. There's 3 of us in this room now, and then Sue is on a separate.
Wait. I just want to let everybody know I just started live streaming. I wanted to call the case number 2020CV101. I don't know that it's really captioned right. It's captioned so far as Douglas County Corporation Counsel versus Montauk Snow Sports LLC. I don't know that's really right. I think the latest caption in Corp Counsel says Douglas County Board of Supervisors as the petitioner. Ms. Pierce is present. I see the county board chair is also present. At some point I did see, the county administrator. I see Mr. Nichols, who is appearing on behalf of Montauk Snow Sports. Ms. Sandvik, the county clerk, is appearing. I see some other people. It's open to the public, so I don't know that I necessarily need to take a roll call unless somebody needed to state certain appearances. I did mute people that weren't parties at this point, just because I didn't want the feedback. I couldn't tell where all the feedback was going. But as I indicated, we are live streaming this hearing to make it public, since because of COVID and we do not have a plan adopted by the Supreme Court yet to allow for reopening in Douglas County. It is streaming, and I do have to say that because we are recording the event, it's being done on YouTube, on our YouTube channel. Nobody is allowed to record anything, since I do have a court reporter that is recording everything that's being taken down, just like we would if she would be in the courtroom with me. So it's scheduled for a hearing. I guess I'm a little bit confused at the outset. Obviously, the court only becomes involved in a hearing such as this, or a case such as this, if there's a judicial review under 6813. And I was a little bit confused on the pleadings because, there's some things, it was unclear to me whether there was some other final determination or the initial determination. I guess I'm not sure, was there an intent that there had been a different evidentiary hearing? There was a request for evidentiary hearing, but obviously the court doesn't conduct an evidentiary hearing. I am just reviewing the decision based upon the record and a transcript of the hearing. I guess maybe Mr. Nichols, you can clarify what exactly is going on procedurally. Is this more than a judicial review?
We believe so, Judge. So let me just get you up to speed as to what's happened. There was a county board vote on Montauk's application for an assemblage license. It did not pass. We're challenging that. And we believe that under WSStat 6809 sub 2, we have a right to review that could have been done by the board itself, but it also can be done, it specifically allows for an independent review by another person, including the judge in this county. And I believe that's how it got referred up to you. And pursuant to WSStat 6809.5, we believe that you as the reviewing officer, now you may affirm, reverse, or modify the vote to deny this application. As for what evidence or argument you take, Judge, it's my understanding that we have a right to put on, we're prepared to make lawyer argument, just talk to you about this based on what's already in the record. We certainly we have Larry Polkerbeck, the owner of Montauk, Mike O'Hara, the manager of the property and the manager of the Bowfest event, here available to provide testimony if you wish, and we're ready to go however you like. I'll admit, as to exactly how the evidence goes in or argument goes in, I'm a little fuzzy on the details there, but we're ready to do whatever you would allow and would prefer.
I guess I'm confused because under 6809, where does it say that the review would be by the court or a judge? Maybe I missed it.
Under 6809 sub 2, it says, I'm going to just quote it. It says, a review under this section may be made by the officer, employee, agent, agency, committee, board, commission, or body who made the initial determination. So that would have been the board itself. The board could have just reviewed this itself. It says, however, an independent review of such initial determination by another person, committee, or agency of the municipality may be provided by the municipality. And it's that independent review piece to it, sort of it's the second sentence of what I just quoted. That's how it got up to you. And my understanding is there's 2 judges up in your district, and you're the one who is designated to review these types of things. I'll admit I may have to defer to Aaron on exactly how it got to you. My colleague Aaron Wygren, who's also on the call, but that's my understanding, Judge, of how we got here.
Yeah, and I'll be honest with you, I've only had one other similar situation involving a municipality like this, and it was, there was a judicial review and that's why, then why would we have 6813 for a judicial review if that's what we would do under 6809, have a formal, it seems superfluous if the independent review, it says independent review, but then it goes on to say judicial review. So I would think that it would be like any other administrative decision. It's not something that I agreed to be the independent reviewer. This was filed in circuit court, and I know there's statutes thrown around, but I guess I looked at it as this was going to be a judicial review. Of course, I was confused because there's been no transcript of the proceedings provided, but Ms. Pierce, how did it get before the court?
Your Honor, I believe it's before the court based on the Douglas County Ordinance 4.13, Section 8, Appeal on Application Denial. Based on that ordinance, it describes that the review, any denial is to be reviewed by the circuit court judge.
I'm just trying to get the code up here. What did you say it was under?
Douglas County Ordinance 4.13, Section 8, Appeal.
Yeah, section 8 entitled Appeal of Application Denial.
All right, so then how does that comport with 68? It doesn't give me grounds. It says, okay, I can either affirm or reverse the initial action, but then what do I review it on, Ms. Pierce? What does the ordinance say about that?
I don't know that the ordinance is specific in terms of what the review would consist of. based on 68, my sense is that it would be a full due process hearing at this point.
Where does it say that?
Based upon, let's see,
No, let me stop you there. Where does it say in the appeal that it doesn't quote 68? It just says, you know, upon written request, have a denial reviewed by the circuit court. Where does it then point to 68 and have a full due process hearing?
doesn't say that in the ordinance, Your Honor.
Okay, I guess it doesn't make sense that I would do an independent review or a full due process hearing, but then there's a right to a judicial review. You know what I'm saying? I'm very confused by how this is done. I, of course, see 68. I look at 68, but I mean, did you anticipate then we're just going to rehear the whole thing and then I was going to make a decision? I mean, if I rehear it, hear evidence, aren't I just making my own decision, not giving any deference to the county board?
I believe that you would, I think the standard that would be looked at is reasonableness, that you would be giving deference to the county board in regards to their decision based on whether or not their conclusion is reasonable. Then you would either upheld the decision or reverse it if it was found to be not reasonable. I think there is a presumption of correctness at this level in terms of the municipality's interpretation of the ordinance. So I don't think it would be the court necessarily just rehearing it and making an independent decision. I think it would be based on whether or not the board's decision was reasonable.
Okay, so, and where does that say that in section 8? That's the process, or that's what I'm supposed to do?
It doesn't, Your Honor.
Okay, so where are you getting that interpretation? You're saying that 68 applies even though it's not mentioned? Or I guess I just want to get it right is my point. And if the point is getting it right and the ordinance gives me no guidance, where do I get my guidance from if the ordinance doesn't even, you know, quote chapter 68?
Judge, if I may weigh in, you know, I agree with you that the ordinance doesn't.
Wait a second. You'll get a chance. I'll ask you to respond, but this was to Ms. Pierce.
Oh, I'm sorry.
At this point, I mean, it was filed under 68. I think that's how chapter 68 became part of this this hearing. The guidelines in terms of the ordinance, though, is clear that it is to be before the circuit court. I think the petitioner has brought in chapter 68 as a means of providing some sort of guidance in terms of how the proceedings should go, what the court should be looking at. It is, I guess, for lack of anything more precise, it is an administrative hearing review. So I imagine that's why it was filed under 68. I can't speak to the petitioner in terms of why he filed it in that manner, but looking at the ordinance, it does provide that it is reviewed by the circuit court judge.
But it doesn't give a standard of review or a deference standard, or doesn't give me what I should review, at least the guidelines. At least under 6813, it tells me what I can look at as far as, you know, the standards. I guess it says I can either reverse or affirm the initial determination or the initial action, but that's all it says. It doesn't say how I do it. So I guess, Mr. Nichols, you're going to maybe shed some light on the conundrum the court has?
Well, yes, and I'll shed as much light as I can, although I can't give an entirely illuminated path. I agree. I mean, the ordinance puts us we're in the right place right now. We can come to you. But the ordinance also says this is not the judicial review under 6813, because if you look at the very last sentence of section 8, it says if the court can't review this by a certain date, we can jump right to the judicial review part. So obviously this is not the 6813. And I agree with you that the ordinance does not set forth the standard of review, nor the what record you get to look at, whether you take new evidence or not. We struggled with this a bit when filing, and we relied on, or we cited to Chapter 68 just to try to harmonize to the best we could the state statutes and this county ordinance. I guess our view of it is that, you are the first layer of review here, and depending what happens, we could seek judicial review under 6813. And I think you're just giving this a fresh look, and it's entirely within your discretion to decide what you want to hear. I say that because there's nothing else limiting you. So in the lack of anything saying you have to defer to the board, or you can only look to the transcript of the proceedings, I think then, without any of those restrictions, you're allowed to make your own decision, sort of a de novo review, and you decide whether you want, the scope of the record you're going to review, and that can include new record evidence today.
And I don't have a copy of the transcript. Is there a transcript?
I'm not aware of a transcript. We have a link to the proceeding, and a link to an audio recording. And we did send that to you. I think it was linked in both of the letters we sent to you, but I'm not aware of a written transcript.
I guess, and that, again, if we don't have a written transcript of it, it really can't be part of the record, because how do we record that as part of the record or a decision that I made? That's, I don't know. I guess that's another question. So Ms. Pierce, am I supposed to just listen to the county board's decision and then decide whether it's reasonable after arguments, or what am I supposed to do?
The county is requesting that there is no transcript. That is true. There is just the recording. In regards to the filings that have been made, I think there is a sufficient basis for the court to review what the determination of the board was, how that decision was made, along with the record of the vote. In terms of accepting new testimony, I think that is up to the court in regards to what would be relevant in terms of making a decision. I do believe that the standard is whether or not the decision of the board was reasonable, and that deference has to be given by the court to their decision. So I think with that in mind is what the court should be looking at in terms of what evidence to accept at this point.
So you're giving me this reasonable standard. I guess I don't see it in the ordinance. Where does it say how am I supposed to review it? It just says I can affirm or reverse it.
I was looking to Supreme Court case Ottman versus Primrose, 332 with second 3. In that decision, the court looked at how a municipality's interpretation of an ordinance should be reviewed by a court, what presumption of correctness should be given in regards to any interpretation made by a municipality to its ordinance. So that's where I was getting the reasonable standard from.
Do you agree, Mr. Nichols, that's what the standard is?
I'm not sure I do. Again, I don't think there's anything out there that provides a standard for this particular ordinance. But again, when we harmonize it all with Chapter 68, I believe we're operating under Chapter 68 sub 09. And there I've got a Seventh Circuit case interpreting Wisconsin law. I can give you the site in a moment here, that says that the circuit court judge reviewing a decision, a situation like this, is, quote, the final policymaker with the authority to review the acts of municipal subordinates, including their compliance with city policy and even the wisdom of city policy itself. End of quote. That does not give a particular deference standard. It certainly suggests kind of broad authority and the type of fresh or de novo review that I'm suggesting. But I'll admit, Judge, it doesn't give us a bright line test of exactly what deference you provide or what you look at. And I can, if you want that site, I can give it to you here. Would you like the site?
Yes.
It's Milestone, just like it sounds, the City of Monroe, 665 Fed 3rd 774, and the language I just quoted you was on page 781.
In case I have to look at email or something. Yeah, I just saw this one.
Did you get a chance to review that case?
I'm sorry, Your Honor, what was your question?
Did it get a chance to review that case?
No.
All right, anything else on the issue, how we proceed and what the issues are, Mr. Nichols?
Yeah, one sort of wrap up point. I'm appreciating now that I didn't do the best job initially of tying the section 8 of the county ordinance into chapter 6809 sub 2. And let me just do that to kind of tie that up a little better, because chapter 6809 sub 2 says that the board itself can review these things, or an independent review of such initial determination may be made by another person, committee, or agency of the municipality may be provided by the municipality. And so when you read it that way, it says the county or the municipality itself can appoint somebody else to do these reviews. And we believe that's exactly what the county did here with chapter 8 or section 8, excuse me, of ordinance 4.13, where they say the circuit court judge shall affirm or reverse the application. That affirm or reverse exactly tracks the language in 6809 and 6809 sub 5. So I didn't do the best of tying those two together, but when I was saying at the beginning that you're the independent person that this municipality has designated to review these, that's what when you read 6809 sub 2 in connection with section 8 of the ordinance, you see how they work together. And then chapter 6809 sub 5 says you may affirm, reverse, or modify the initial determination. So that's how you harmonize them together. And I didn't do the best of explaining that to you when I was giving you my initial answer.
Ms. Pierce, any final words, and maybe you can address that issue and why the ordinance then leaves out or modify?
Your Honor, I don't believe that the ordinance necessarily mirrors that provision. The ordinance does leave open the question of even who would review. If this is just the initial determination, it doesn't answer the question of how a judicial review would occur, how a review of certiorari would occur. So I think that question is left open. In regards to the determination, I would stand by my earlier argument that what the review standard at this point would be reasonableness based on that Supreme Court case that I cited. In terms of treating this as a certiorari review, I mean, I think a transcript would be required. That has not been provided. Under 6813, it's required that the appellant be the one to provide that to the court. The county is prepared to go forward today in terms of this as judicial review, but it isn't complete without the transcript. So.
Well, I mean, if it was a judicial review, the county could have easily just put and added the statute judicial review under 6813. They didn't do that. So obviously this isn't a judicial review. The other interesting part about it is the ordinance doesn't give me the standard. The ordinance could have said reasonableness. Now, by using the language such as affirm or reverse the initial action of the applicant on the application, I think that means that I'm reviewing something, and it just depends, what am I reviewing? Well, in most cases, when I'm reviewing the decision of a municipal body or of a administrative body, which this is likened to, I get a copy of a transcript that I can review. I don't think that the ordinance requires it. The ordinance doesn't even say what I'm to review one way or the other. But what I can say is I've reviewed the filings, and I guess as far as the transcript, I was waiting to get a transcript because I assumed it would be akin to a judicial review. But how can I give deference, full deference to the county board if I don't have a transcript of it, and the ordinance doesn't say who provides it? The ordinance doesn't say that the petitioner provides it. It doesn't say that the county provides it. It doesn't say that there has to be one. So I guess as a threshold matter, I think that in order for me, I think the language of Section 8 isn't the same and isn't exactly the same as 68, either 13. It can't be 6813 judicial review, because then you could have just put it in there. You could have put this as a judicial review under 6813 and added in the additional language of or remand, but that's not what happened. The ordinance could have listed, well, this is a review under 6809, but the ordinance doesn't say that. But I think by using the language affirm or reverse the initial action, I think what that means is I do have to look at something, and I have reviewed the file in its entirety, but what I'd really like to have is a transcript of it in order to give full deference to the board. I'm not sure how quickly that can be made for the court to be able to review, but I hate to make a decision without giving full deference to the county board by having the transcript. And I don't think that I get new evidence, because I don't think that the review means that I get new evidence on the issue. So it would be basically rehashing and arguing what was already presented. That's my review as best as I can tell of Section 8 and harmonizing it with due process. So that being said, I'm not sure how you would like to proceed, Mr. Nichols.
Well, let me ask you a couple of questions before I answer, if you don't mind. Did you just say that you will not be taking new evidence?
I don't think my review of it is, I don't take new evidence of it. I just review what has previously been looked upon. I think that's what the intent behind it would be. I'd be acting like a court of appeals. I wouldn't be reviewing, I wouldn't be doing de novo like I would of a court commissioner's decision, because it does use the language of appeal and either affirm or reverse, which to me means I'm affirming or reversing a decision giving deference, some type of deference. What the deference is, I'm still trying to ascertain.
Sure. Well, let me tell you what the core issue here is that I want to argue and would have presented evidence on, and it's fine that we don't, and let's figure out how best to handle this. The core issue here is that this application was denied based on, frankly, a mistaken assumption of fact. The county evidently is assuming that on the Thursday, July 23rd, the Thursday of BowFest, we are going to exceed 1,000 people. That's critical, because only by exceeding 1,000 people for 6 straight hours would we even then need to seek a license for a public assemblage. They've listed 5 or 6 reasons to deny the application, but they all go to that same, they all come back to the same issue of criticizing us for not seeking a license for that Thursday. Well, what we were coming here to tell you today is we're not going to hit 1,000 that day, nowhere close. And in fact, my client's prepared to say, we'll just limit attendance. I mean, we can explain why we're not going to get anywhere close to 1,000 based on past practice and ticket sales and the like. And so we can tell you why we didn't apply for the Thursday because of that past practice. But we'll take it a step further and say, we won't allow there to be 1,000 people that day. And so that's the entire issue here, Judge, comes to this. Are we going to get to 1,000 on Thursday or not? They denied the entire application for Friday, Saturday, Sunday as well, based on this Thursday mistake. And part of our concern here, Judge, one of the things I was prepared to say today is we didn't get a fair process here. Whereas, we had no opportunity to share this information with the board. Frankly, I suspect of the 19 or 20 board members, however, most of them don't even know what I'm saying to you right now. They don't even know that we're not going to be anywhere close to that 1,000-person threshold on Thursday. And a big part of what I was going to show you today is process issues. Last year when we applied for this, we had a very collaborative back and forth where my client was given an opportunity to answer questions, make a presentation to the board, talk about expected attendance, what we were doing to control it, move people around. It went off exactly as it should. The board asked the right questions, and my folks were able to give them the right answers, and it sailed through resounding yes vote. This year, we weren't given any of that chance. None of these issues were raised in time for us to do anything about it. We weren't asked these questions at a hearing. We weren't given a chance to share this information, and they went ahead and denied it. And it all comes down to this mistake, this mistaken belief by some that we needed a license on that Thursday and that we somehow broke the rules by not seeking a license on the Thursday. So that's the rub, and where, to get back to your question of what should you be reviewing, it's a little bit tough for us because the record doesn't, what I just told you about this 1,000-person threshold, there's nothing in the record because we weren't allowed to say it. We didn't even know this was a concern until it was too late. So that's been the problem with this whole thing, that we weren't allowed to share this. And had we been allowed to share it, I'm pretty sure this would have passed and we wouldn't even be here. So it's kind of a one issue dispute here, Judge, and that's it.
What about the timing of it? Because obviously that was part of it, that it wasn't applied for timely.
Exactly, and there too, that comes back to the Thursday. If we needed an application, if we needed a license for Thursday, then we were arguably 1 business day late in filing the application. But if we don't need it until Friday, then the deadline falls on the weekend and we have until Monday and we're timely. So when I say everything comes back to this Thursday thing, I mean it, everything comes back to the Thursday, whether it's the timeliness of the application or there was allegations that we didn't provide accurate information. And what that goes to is we're advertising it as a 4-day event, but we applied for a 3-day license. And that's not because we were being dishonest. It's because we only need a license for 3 days, since it's only on 3 days that we're going to get anywhere close to the 1,000. And even then, by the way, the 1,000, that threshold, it only gets hit. We have some concerts scheduled on Friday and Saturday night, and we sell separate tickets to those concerts. That's the only time we're likely to hit this threshold. And even then, Judge, it might not hit the 6 consecutive hour thing. So to be honest, I'm not sure we need a license for any of this. But we tried to err on the safe side and apply for it, and here we are.
So under the ordinance, could I even remand it back for a new hearing because it says reverse or affirm? What's your position, Mr. Nichols?
Well, you hit on something. Why doesn't the ordinance say reverse, affirm, or modify? And we think the right to enact this ordinance comes from 6809. Where did I put it down? Comes from chapter 68 overall. 6809 is the part that allows you to be appointed as that independent review person. 6809 sub 5, that's what says you affirm, reverse, or modify. So I do think you have the right to modify. And yes, we believe that one of the choices, we believe you have 2 choices here. Well, 3. You could affirm it, or you could say, no, I'm reversing it. I'm going to grant the license, or I'm going to remand this for another vote, but I want to make sure that Montauk gets a chance to present all of its information and, address any concerns the board may have, and frankly, educate them on this attendance issue. Because I'm really confident that if you ask those board members, they probably are of the mistaken belief we're going to have a giant crowd on Thursday, and that's just not going to happen. And again, Mr. Paul Quebec is here. If he were giving evidence, he would tell you, I'll promise you we won't. He'll tell the board the same thing. You want us to have less than 1,000 that day? We'll guarantee it. We'll just limit the attendance. I would also tell you this, Judge. Since we learned that this Thursday was the issue, we actually went ahead and paid. It's a $10,000 bond per day, and we had paid for the 3 days, so $30,000 as of the date of the application. Once we found out this was a problem, we went ahead and paid in the extra day. We said, fine, if you guys want more bond, here you go. If they want an additional license fee, we'll give it to them. We're trying to make this more like last year's process, which was very collaborative, and we were working together. Everybody agrees this is a good event. It's good for the local economy. It's a positive event. No one has any complaints about anything. This is a really good event. So we just want to work with our municipal partners to make this happen. And we're willing to do that.
Ms. Pierce?
Yes, Your Honor, I don't believe that it boils down to just one issue. I think to begin with, the application was not filed in a timely manner. I think there was evidence that's been presented at the county board level in terms of Mr. O'Hara, who has been in charge of working on the application with Douglas County in the past, that he made no contact with County Clerk Sue Sandvik until 1 day, 2 days after the initial application would have been due. His first contact was on April 27th. The application was due on April 25th, even if you don't take into account the dispute on Thursday. So the application was late. That's part of the reason that it's not been a collaborative effort this year. In the past, last year, the county clerk, zoning, the Department of Health and Human Services did work with Mont on this project. It was the first time that this license had been granted. And so there was a lot of back and forth, but that all took place before the application was due. There were amendments made after it was conditionally approved, but Mr. O'Hara was very involved with the county. This year he has not been. The county has had no information regarding the festivities until a contact was made on April 27th, indicating that he was hoping to get the application in that week. It was already late. Since the application was put in, there were numerous deficiencies in terms of even correctly stating what dates that were. Not taking into consideration July 23rd, but the application actually only states that the festivities will be held on July 24th and July 26th. The 25th is not even referenced. There's issues in terms of the ticket sales that have occurred. There's records that indicate that over 800 tickets have already been sold to the Boat Fest, and those are 4-day tickets, which would include that Thursday, which Mont says they're only going to have 200 people there, but their ticket sales indicate otherwise. Their social media posts indicate otherwise. The board chair, along with the administrator, were aware of the social media posts that were both on Facebook as well as bofest.org, which represented that they expected up to 10,000 people. It's not congruent with what council is saying or what the application said. And part of the reason for the denial of the permit was that there were material and fraudulent representations on that application. The board should have the discretion to make that decision based on protecting the safety and welfare of not only the participants there, but the wider Douglas County. The ordinance originates out of Chapter 59 and the powers of the county to protect both order and peace. And that's where the ordinance starts or was enacted from. So their concern about the welfare is why it was denied. And in terms of this dispute about whether or not there's going to be 1,000 people that show up on Thursday, I think that should be left to the hands of the county board in deciding whether or not they believe that a license is due for that day. The reason for having the license is to make sure that there are appropriate facilities to keep people safe there. It requires sanitation, security, fire, provisions. And based on the application that was put forward, there was no information for the board to decide whether or not those interests would be protected on July 23rd. So that was the reason for the denial. We could quibble all day about whether or not there's going to be 1,000 people there on Thursday. Nobody has a crystal ball to say for sure, but I think that the postings in terms of social media, the fact that they've hired a national band to come and play on Thursday, which was not the case last year, I think they're attracting up to 1,000 people that day, and it was within the board's discretion to require a license for that day.
And what's your response to not having gotten a full hearing the first or in front of the county board when Mr. Lustry submitted? There's the evidence that was submitted regarding Mr. Lustry.
I do believe that the Mont did receive a full hearing on the board floor. Unfortunately, as we all know, this is strange times to be having meetings. Due to the pandemic, Douglas County does have a state of emergency in effect, and all board meetings have been held by telephone since that declaration back in March. Committee meetings are not even happening at this point because of it. The board held April meeting and had no problems with communication via telephone between board members. In regards to what happened at the hearing or at the board meeting in May, the county would admit that there were problems in terms of static and feedback, but the vote was clear. The motion to deny was passed, and Mr. Lustry unfortunately was not able to communicate his vote. He indicated that he was able to listen to the hearing, but he was one of the only supervisors that indicated any issue. Further, Monolac was provided notice not only on May 13th that the board recommendation going to the board was to deny the permit. They'd also received, or it had been agendized on May 7th that the board would be recommended to deny the permit. So I think it's disingenuous to say that they didn't have the ability to react to the recommendation of denial. They were fully informed. They could have provided evidence, and they did not. They appeared, Mr. O'Hara appeared at the meeting via phone. He did have engaged in discussion both with myself as well as different supervisors indicating his position. So I do believe that they did get a fair hearing in terms of the permit.
So it's a fair hearing when one of the county board members could maybe understand a quarter of what was being said? It's
the nature of the times that we're living in right now. The county board needed to act on business. The only safe way to act on the business was to do a telephone conference, and that's how the meeting was held.
Okay, so what is an acceptable amount to be able to hear to have a fair hearing?
In regards to an individual?
Well, I mean, you just said, you know, that's the times we have, that's the best we can do. You know, one county board member is just as important as every other county board member. You'd agree with that?
Correct.
So when one county board member say, I could only understand maybe a quarter of what was being said, doesn't that call into question the open and honest debate that we as a democracy have?
I would agree that it does, Your Honor, but I believe it is the only option that was available at that time. I also believe that the vote would not have been changed in regards to that one individual.
But you don't know, because if they were only hearing a quarter of it, how much could they communicate what their opinions were that may have changed the mind of other voters? How do you know that?
Are we discussing Supervisor Lustry?
Yes.
And I mean, he was unable to vote. That was established through the emails, but in terms of the ability to communicate with one another, I don't believe that he indicated that there were things that he wanted to share with the board at that point. And again, it's during the times of COVID, it's unfortunate that it played out that way. There were certainly steps taken by the county clerk as well as county staff to ensure that it would be a fair process, and steps were taken during the meeting to try to reduce feedback, to help supervisors understand how to unmute or mute themselves. So the county took all precautions and every step that it could to make it a fair process.
And I agree, we're in odd times, and I'm glad that the county board was meeting. I mean, I think that was excellent. But my only point being, if you do have these problems and they come into question, isn't there a remedy? Couldn't you have offered, well, we had one county board member that could only hear maybe a quarter of what was being said to their constituents and to that county board member. Isn't it fair to give them a new shot, or do you just say, well, it was close enough?
I guess I'm not understanding what the other shot could be in terms of, under the ordinance, it would be too late to go to. We were under restrictions via the ordinance that we had to, county board had to have a vote within 45 days of receiving the application. Next board meeting would not, the board meeting of June would not fit into that time frame. So that was the reason that the vote was taken at that point and why we've stood behind it.
So then, and I guess that goes to show, so that if I remand it back to the county board for rehearing, how would you handle that?
My thought would be that to begin with, I guess both sides would have to waive that provision of the ordinance in terms of the county board having to take action within 45 days. It still brings in.
Well, ultimately, I mean, the reality is I have 90 days to make any decision. There's nothing in the ordinance or in the chapter 68 that says I have to make a decision, you know, also, but of course we got this on the calendar quickly to make sure that everybody had their full, at least had a say and we could get this moving along. I certainly understand time is of the essence. How is the county board going to be meeting in the future?
At this point, we are expecting that we will be having at least some of the supervisors in person for the June meeting. That, unless there's a spike in COVID cases.
They'll have the option.
Okay. I guess as just threshold matters regarding this issue, I could just tell you that the thing that concerns me the most about this isn't, you know, what the decision was made. Quite frankly, with the review that I looked at, I'd be hard pressed to find that the county board wasn't reasonable in their decision-making process. I think it's one of those standards. If I give deference of reasonableness to the county board, I think their decision was reasonable. I guess my biggest concern about it, reviewing the record, was one county board member only having, and that's why I kind of pressed people on it. I really think in these times, it's just as important to give due process as any other time. And by having one county board member not being able to understand or a quarter of what was being said, that causes me great concern. And maybe the vote turns out the same, maybe it doesn't. But, you know, one person's voice on the county board is just as important as every other voice on the county board. The problem is, you know, the ordinance doesn't give me the ability to necessarily remand. It just says I can either affirm or reverse. I suppose by the process of saying reverse, I can reverse and remand for a new hearing. The question becomes whether or not that's going to be soon enough in order to make all this stuff happen. I don't know, but that's my biggest concern. I don't think I can take any new evidence on the issue, and it's always interesting hearing about, well, 1,000 people this, 1,000 people that. I agree with the county that the 1,000 people, I mean, if you're selling 1,000 tickets for a four-day event, how can you say with 100% certainty there won't be 1,000 people? You don't know, and I certainly understand Montelac's position while we were erring on the side of caution. But I think if you sell 1,000 tickets, you're disingenuous to say there's no way we're going to have 1,000 people. I mean, we can't get into debates about 1,000 people or not 1,000 people. I agree with, you know, the county on that position, but I guess it leaves us with, I don't think I can take any evidence on the issue. It continues to be argument, and then I guess argument about, you know, what any of these other things mean and where we go. So I guess I'll leave it for If you want to point my attention to one thing or the other, I don't intend on taking 90 days to issue any decision. In fact, I think I'd issue the decision fairly quickly because I think it's important to know where people are going. I could even potentially take a break and review some things if I feel comfortable making a decision from the bench. Mr. Nichols, I want to give you, I guess, another say. If there's anything else you want to add, I'll give Ms. Pierce one more chance and you would get the last word. Or if you think there's things you want to point me into. I've reviewed the record. I mean, I can tell you that. I've reviewed everybody's filings at least once, if not twice.
Sure, Judge. Thank you for the opportunity, and I will be quick. This back and forth here is exactly what should have happened in front of the board. I mean, I think you're pointing to the one board member who only heard part of this. I think it's fair to assume, that may be the only board member who spoke up, but I doubt he was the only one who was having trouble hearing some of this. And frankly, we've had board members reach out to us directly saying that was kind of a ridiculous process. We think you would have passed had you been there in person with a chance to explain things. And I do want to highlight just this key process point. Ms. Attorney Pierce said that we were put on notice of what the concerns were and given a chance to respond. That's not true. We were sent, and it was Exhibit F to my submission on Friday, Judge. All we got was a letter 3 hours before the hearing, written by Ms. Ann Doucette, the county administrator, and Mark Liebert, county board chair, outlining 6 alleged deficiencies. They sound real bad. One of them even says false and misleading statements. If you read through this, Judge, you'll see it all goes back to the Thursday issue. For example, point 5, false and misleading statements, is the contention that we're marketing it as a 4-day event, but we didn't seek the license as a 3-day event, as if we somehow misled them. But the other explanation that the board would have heard had we given a chance to present it was that we don't think we need a license on that day, and here's why. And we could have explained to the board, you said we're not going to have the debate now whether it be 1,000 or not. Well, that debate should have been had. That discussion should have been had is in the board meeting, so the members could have made an informed decision about this. But they weren't given that choice. Instead, they were just given this fairly harsh sounding letter that was written ahead of time and given to them. They didn't hear the facts. They heard somebody's characterization of the facts, which we were given no opportunity to refute. And I would direct your attention to something else, Judge. Compare Exhibit A, which is the meeting minutes from last year, where the board considered our BOFEST application, with Exhibit H, which is this year's meeting minutes. If you look at last year, front page of the minutes, it says all application materials and documentation attached and reviewed. Mike O'Hara, manager, presented an overview of the events, expected crowd size, campground permits, and required provisions for security as required. It reflects the discussion that took place, the opportunity we were provided to share the facts so that the board could make an informed decision. Compare that with Exhibit H, the meetings from this year. There's nothing in there but a discussion. It just says, recommendation of county administrator to deny. They started the meeting and they went straight to, let's deny this. No discussion, no questions, no chance to respond to what we think was a very unfair characterization in this 6-point letter that was shared 3 hours before the meeting. So, I mean, this was not only an unfair process to us, it was unfair to the board members. They were forced to vote where some people can't even hear what's being said, but on a very misleading record. I mean, the board members, they have a right to have another hearing on this so they can go, I want to actually hear more about this event. Because last year, we passed it 19-1, and this year somehow it failed, even though almost everything is identical this year and last year. Almost everything is identical. The only difference, Judge, is COVID. And you saw we're good on that. The sheriff took a close look, said, I'm totally confident everybody's going to be safe. The health department gave us a permit. So, I mean, this isn't a COVID issue. We crossed that hurdle with flying colors. This is all about this letter that was written that we think kind of poisoned the well. The board members see this and they go, oh, geez, it sounds like this application wasn't even close. But take a close look at those 6 points, Judge. They all go back to this Thursday 1,000-person debate. And we could have had that discussion with the board members before they voted. And what we're asking you to do is to reverse and remand to give us that chance to tell the board members exactly what's going on and let them make an informed decision. As the timing, Judge, I don't know that this has to wait for the next June meeting. I think they could schedule a special meeting to address this. I mean, city councils or other municipal agencies do that all the time. So I think what should happen here, Judge, in the interest of due process, in the interest of fairness, both to my client and to the board, so that, look, remember, the board represents the community and everybody agrees this is a good event for the community. I think the board's going to want to be able to say, we really vetted this, we really looked at it, we heard from everybody before they make an important decision to affect their community. So I think there should, what we're asking you to do, and what I think makes the most sense here, is reverse and remand for a new meeting and a new vote, one done as quickly as possible. And I agree, part of it can be in person, whoever's comfortable, and we'll show up and take whatever social distancing or other safety precautions the board folks have in place for us. We just want our chance to tell our side of the story and make sure folks have the facts.
Ms. Pierce?
Yes, Your Honor. Council likes to paint this as there's some conspiracy on the part of county staff to sink this application, and it's simply not true. I think what's happening is Mont is trying to get another kick at the can because they didn't get the outcome that they wanted, and yet they didn't participate before to try to provide the information to the board in regards to what they're now saying is they're only going to have less than 1,000 on Thursday, and talking all about the number of participants that are going to be at BowFest. None of that information was shared. Council is right that last year there was a presentation in front of the board. That presentation was requested by the county board, but this year there was no reason for the board to request that. Mr. O'Hara, Mont should have been making the request for the presentation if that's what they wanted to do. If they wanted to address the board, they should have made a request. They would have been put on the schedule. They would have been able to address the board in the same manner as they did last year. In terms of what they provided to the board, they provided the application. The application was not complete, and it contained many inaccuracies, as well as it was filed late. That's all the board had to rely on, as well as the research that staff had done into the matter, which that's staff's job to vet these applications, to provide a recommendation to the board. And that's what Ms. Doucette did, that's what Ms. Sandbeck did, that's what I did myself in terms of looking at the application and coming to a recommendation that the board then was able to consider. So I don't think we should be villainized because we provided that service, which is part of our job. In terms of where we go from here, I would argue that the court should continue to deny the permit, that the actions of the board were reasonable, that due to COVID, the meeting was less than what we would have wanted it to be in terms of there was at least one supervisor who has indicated he wasn't able to hear. But the process was fair. Mr. O'Hara did present information to the board that night. Mont also had noticed way back on May 7th that the intent from the administrator and the chair of the Board of Supervisors was to recommend denial of the license. So contact could have been made at that point, but nothing was done. So this idea that we sprung the recommendation on them 3 hours is disingenuous. They had noticed back when the agenda was publicized on May 7th. So we would ask that the denial stand.
All right, Mr. Nichols, you have the final say if there's anything you want to respond to, add, or point my attention to.
Sure, just real quick. I gotta clarify a couple of things there. One is, Ms. Pierce just said we had notice on the 7th. I think we made that clear in our filing ahead of time, Judge. All we knew on the 7th was that there was going to be a motion tonight. We had no idea why. These alleged deficiencies, all of which relate to one thing, the Thursday 1,000 people threshold. We did not know that until we got Exhibit F, that letter, 3 hours before the hearing. That was the first we knew what the county's concern was with our application. So this notion that, oh, but then it was incumbent upon us to have requested an opportunity to present and clarify the issues, that's not fair. We did not know until 3 hours before. And Judge, I urge you, if you are going to take some time, I urge you to listen to that meeting. I mean, it's only a 25-minute recording. As far as I know, it's still available on the link. I'm pretty sure it is. I mean, heck, you could listen to it right now and still get back to us today, perhaps. I don't mean to rush you, but the bottom line is it's an easy thing to listen to. But the second thing is Ms. Pierce keeps saying that there were problems with the application. There were numerous deficiencies. That isn't true. I know she broke it into 6 separate things on this letter. It all is the one thing. I mean, when they say false or misleading statements, that's because we didn't apply for the full 4 days as opposed to 3. When they say sanitary facilities not addressed, they say, well, you didn't tell us what you were doing on the Thursday. It's all the one issue. There were not numerous problems. It's nothing like that. Look, Judge, we filled out the application just like last year. We sailed through last year. This is a great event just like last year. The only difference that we're fighting about is this 1-day thing. So I just want to clarify the record. There were not numerous problems with our application, numerous deficiencies, right? There's one thing that they're trying to break into several parts. That's not true. And again, I'll just close with this issue about how many people are going to be there. That's a discussion that should be had in front of the board members so that they can make an informed decision knowing the facts. So thank you, Judge. Appreciate your time today.
Thank you, Mr. Nichols. I guess what I'm going to do is I'm going to take the matter under advisement. Unfortunately, I mean, it's got to be done fairly quickly. I'm going to start looking at a few things and drafting a decision today, but there's a couple of things I want to research, and I don't think I can keep you guys waiting on the line to do that, to try to make some type of oral decision. So I'll get a decision. Hopefully I'll have it done by the end of the week, and then you guys can go from there. Was there anything else that we needed to address today, Mr. Nichols?
Nothing from me, Judge.
Ms. Pierce?
No, Judge.
All right, thank you.
Thank you, Judge.
Thank you.